Welcome to our sixth lecture covering the nature of the employment relationship. If you're following along with the PowerPoint, you'll see that we have moved on to our second PowerPoint. And so let's begin. In our first 5 sessions, we talked about our first 2 topics in Module 1, and you'll find both of those in the first PowerPoint. The first was very short, it was just kind of a course introduction, and then the second section is what dominated that first portion of the module, and in fact kind of dominates the whole module. And that is how we think about the worker. How do we define that term, and how do we address certain special situations relating to employment. In the remaining part of Module 1, we're going to talk about the employer side. Obviously, we need to define what an employee is, but we also need to define what an employer is. And finally, we're going to talk about non-competes and similar arrangements at the end of this chapter. For this lecture, our goal is to cover this point number 3, the business as an employer or principal. So let's begin. So one of the things that you're going to be thinking about when you are giving advice to your client or to your employer is, well, does this particular employer meet the definition of employer in the statute? And your first thought might be, well, gosh, I know that my employer is an employer because it employs me, or I know that my client is an employer because it has employees. But that isn't necessarily what the answer to the question is going to be. The definition that we find in statutes oftentimes does not match the ordinary meaning that we ascribe to a particular term. For example, you could have a statute that defines child to be somebody younger than 12 years old, or you could have a statute that defines somebody to be a child who is under the age of 19 or under the age of 18. Or you could have a statute that defines a child as being the natural born or adopted heir of a particular person. And so in that case, the child could be a 50 or 60-year-old person. And so when we use a term from a statute, we always have to check to see what that term is defined as in the statute. And you'll find a definitional section in most statutes. Not every single term, obviously, in the statute is going to be defined. And so generally, if a term isn't defined in the definition section or in another portion, because sometimes there's multiple definitional sections, unfortunately, but if you can't find a definition anywhere in the statute, then ordinarily we're going to apply just the common meaning with respect to that word. Sometimes a court may have opined about the correct meaning of that word. And so in that situation, obviously, we would look at some case law to see how that term is interpreted. So that kind of gives you an overview about how definitions work in statutes. I've posted on Canvas some examples of definitions of the terms employee and employer from some of the statutes that we're dealing with to kind of give you a flavor of how those definitions flow. And you'll see when you pull up those sections on Canvas that you're actually in a separate section of the statute called definitions. This section of the statute can appear in different places in different statutes. It's pretty common for it to be one of the first sections, but that's not always the place that you're going to find it. Most statutes, though, are going to have that section. Having said that, sometimes they will have that section, but they will also have definitions sprinkled within the substantive part of the statute. So it would be nice if there was one-stop shopping for all definitional needs, but that's not always how it works. Anyway, so now let's address the issue of what is an employer. As we consider who is an employer, obviously if an entity isn't an employer under the statute, then that particular law doesn't apply to it. Even if the employee half of the definition does apply. So for example, you could have a situation where you have somebody who's clearly an employee, but that employee works for something that isn't an employer under that particular statute. In that case, that statute is not going to apply to either the employer or the employee. Another thing that sometimes happens with respect to these statutes is that an employer can kind of fall in and out of coverage. We'll see that's especially common when you have a number threshold. Well, it could be that an employer, a relatively small employer, is above the threshold, and then there's a layoff, or some natural attrition happens, and then the employer falls below that threshold, and then maybe the business grows a little bit more and it goes above that threshold. So this can be sometimes a moving target. Sometimes you'll also see that an employer can meet the definition for some of its units, but not for other of its units. The classic example of that is the Family and Medical Leave Act. Even very, very large employers like Walmart are going to see that some of their units do not meet the definition of employer in the Family and Medical Leave Act world. And so sometimes you need to get quite granular about these definitions. We've already discussed the issue about joint employer / joint liability issues, and obviously those are in play with this topic. We've already kind of talked about those, so I'm not going to repeat that material again. So let's start by talking about some special cases. One special case that comes up is when the quote-unquote employer, when I say employer here, I'm not using the definition, but I'm talking about an entity that employs. So think about me putting the word employer in quotes here. So the quote-unquote employer is a private membership club. In those cases, they are usually exempt from most of the laws we're going to be talking about. Now that doesn't mean that they don't have employees. They may actually have many employees. When I'm thinking about this, I might be thinking about a country club or something along those lines. And so those, in many of these statutes, are going to have a carve-out, but not all of these statutes. So again, that's when you have to drill down and see exactly what issues are percolating in your particular matter. There can be issues relating to the entity being a multinational company. And it can be important whether it's US-based or whether it's from a different country. Sometimes entities, large and small, may have affiliates and subsidiaries and parent companies. And so figuring out how all those entities work together and whether we combine the number of employees to come up with a large number or whether we look at each entity separately is an important issue. And so when you're close to that bubble, when you're close to that threshold amount, you're going to have to do a little bit deeper dive to see actually how that calculation happens. Then another issue that we want to be thinking about is whether this particular entity, this particular quote-unquote employer, supplies goods or services to the federal government especially, but it can also be state and local governments. There are particular rules that apply to government contractors that don't apply to other employers. And so as we make this analysis, that's another level of analysis that we'll want to think about. We'll talk more about that in the affirmative action chapter as well. Here are just a few statutes that include statutory definitions of employers, and I've provided a few of these definitions in Canvas. One item that's missing from this list is the Family and Medical Leave Act, also the National Labor Relations Act. So this is by no means an exhaustive list of the statutes, but it kind of gives you a flavoring. And I think it's fair to say that each one of these definitions, either for employee or employer, is a little bit different than the other definitions. So you might think it would make sense to have a standard definition. I don't disagree with you, but that's not how our legislature has done. You may wonder, well, why hasn't it done that? That would make life a lot easier. I think it goes back to a few different ideas. One is that these laws weren't all passed on the same day. In fact, probably none of them were passed on the same day. In fact, these laws cover, if we include the National Labor Relations Act and the Fair Labor Standards Act, these laws go back to the 1930s, and some of these laws, if we were to add the Family and Medical Leave Act, go well into the 1990s, and the Americans with Disabilities Act is 1990s as well. So we're talking about, 60-ish years. And of course, if we look at the Civil Rights Act of 1966, we're even going back 1866, we're even going back farther than that. So there were different people in the legislatures at those times. And our country was different. Our ideas about what situation should be covered and what situation shouldn't be covered has evolved. Another issue, which isn't so much time sensitive, but maybe politics sensitive, is that the negotiation process for these statutes is a bit of involves a bit of horse trading. One side gives a little here, another side gives a little here. One side gets a win in this category, but they only get a win here if they're willing to make a compromise somewhere else. And one of the areas where compromise often happens is about the definition of employee and employer. And so that can be one of the reasons why you may look at this and go, why does one statute have 15 and one statute has 20? There isn't a great answer to that, except that there was some horse trading going on with respect to these statutes. We were talking before about private clubs. Title VII, as well as many of the discrimination statutes, don't apply to private membership clubs. They also don't apply to Indian tribes generally, although some aspects of these laws do apply to Indian tribes. And they don't apply to corporations that are fully owned by the United States government. For most of us, these aren't going to be exceptions that really make a difference to our practice. But if you happen to, for example, go to practice in Oklahoma, maybe the fact that Indian tribes are excluded from much of the coverage could be relevant to your practice if you happen to represent a lot of Indian tribes. So there are things to kind of keep in the back of your mind, but for most of us in our practices, these exceptions really aren't going to be too relevant. And I showed you how the Age Discrimination Employment Act doesn't carve out these exceptions. I don't really care about you memorizing whether Title VII includes this exception or the ADEA doesn't include this exception, but I do want you to be aware of these three exceptions sometimes being exceptions to some of these statutes. Because if you're not aware of the fact that these can be exceptions, it won't be on your radar when you get a client who fits into one of these categories. And then once you're aware of, hey, wait a second, this is an Indian tribe, maybe I ought to research to see which one of these laws apply, it's at least on your radar screen. So know these three examples. Let me just mark them here. Know about example 1, example 2, and example 3. But you don't need to know which statutes include these exceptions and which statutes don't. The Fair Labor Standards Act has a really broad definition of employers. So that much broader than we would see with Title VII or the ADEA. So we'll see, and maybe this is a function of the fact that this was a much earlier statute. Oh, by the way, when I talk about statutes, you never need to know the year of the statute. I usually provide it because I think it's a nice context so you can remember, hey, this was a really long time ago, or this was fairly recently, to give you a point of comparison. But I'm never going to ask you what year was the Fair Labor Standards Act initially passed, or what year was Title VII initially passed. If you could only remember one year, though, this would be the year to remember, 1964. It was a time of great change in the United States. President Kennedy had just been assassinated in November of 1963, and Lyndon Baines Johnson was our president, and he pushed for very, very dramatic, significant, momentous, historic changes. And the Civil Rights Act of 1964 is one of those huge, huge changes. So it is a historic year certainly from an employment perspective and from an American history perspective. The other years, I think it's useful, for example, to know the Fair Labor Standards Act passed during the Great Depression, as did the National Labor Relations Act, but the particular year, not so important. Okay, so as we said before, many of these statutes do exclude small employers. You may wonder, well, why do they exclude small employers? A lot of that comes back to really two ideas. Number one, small employers lack the infrastructure to be able to dot the I's and cross the T's on a lot of minutia in the law. Large corporations have legal staff whose job is to make sure that all of the T's are crossed and all the I's are dotted. But a smaller business isn't going to have an attorney on staff, probably isn't going to have an attorney on retainer. It may simply be one person running the whole business, and that person is unlikely to be highly skilled in employment law. And so asking that person to be an expert in this area is not one that would lead to a lot of support for small businesses. And of course, small businesses become larger businesses. And once they become larger businesses, then these laws start applying to that entity. So that's one reason. The other reason is that smaller businesses oftentimes have a more informal method of making personnel decisions. They may tend to hire relatives or next door neighbors or friends. In fact, they may initially be paying people relatively small sums of money because they're just starting out. And so some of the people working for them may be kind of quasi-volunteers. Under the Fair Labor Standards Act, they are going to be covered, so the individuals are going to be entitled to minimum wage, but the true skill level of these people may be such that they could ordinarily draw a wage much higher than that. So the whole employment relationship is a little bit different for some of these very small businesses than exists, say, for a Walmart or a Target or an Exxon. So for that reason, very small businesses are not covered by Title VII or the other laws. In fact, the threshold for Title VII is 15. You do need to know the 15 number. You don't need to know the rest of the definition. And this is the rest of the definition. I'm going to talk about it, but you don't have to commit this to memory. So we need to have at least 15 employees in order for Title VII to apply. But one of the challenges with figuring this out is, well, do they have to all be employed on the same day? What if we have 15 on Monday, but Sam quits on Tuesday? And so we only have 14. Does that mean we're no longer covered? Then the next day we hire somebody to replace Sam. So we're back up to 15. So we suddenly covered. How do you know these is constant on and off? That wouldn't make a lot of sense, right? We'd all agree that'd be kind of a crazy system. And that's not what the statute provides. The statute provides that entities are covered if they have 5 or more employees for each working day in which 20 or more weeks in the current, in each of the 20 or more weeks in the current or preceding calendar year. So you can see it becomes kind of a rolling average. So the loss of one employee on a particular day is not going to cause an entity to suddenly unexpectedly drop below, or the hiring of a particular employee on a particular day is not going to suddenly cause them to jump above the threshold. You'll see this 20 or more week calendar circumstance is also in play with the Age Discrimination Employment Act, but here we see 20 days. Again, I'm not defending this. It's crazy that we have 15 in one statute and 20 in another, but that's the way it works. You do need to know 15 and 20, and you do need to know the 15 is associated with Title VII, and the 20 is associated with the ADEA. We have another statute, which is what we call a Reconstruction Statute. This is a statute that was made into law by Congress shortly after the end of the Civil War. And so this was during the period of time, shortly, that we refer to as Reconstruction, where we were reconstructing, reconstituting the United States. And many of the laws that passed during this era were designed to address concerns about the rights of African Americans, many of whom were recently released from involuntary servitude, slavery. And so they were designed to give those individuals more opportunities to participate in the economic life of the community. And that's one of the reasons that we have the Civil Rights Act of 1866. we will talk more about the Civil Rights Act of 1991 later on. This is an amendment to the Civil Rights Act of 1866. This law obviously is in many of our lifetimes, and it amended several aspects of the law. So that this is the, we distinguish between these two, although if you're actually reading the statute, there's no obvious indication that you're in a different statute. It's very common for one bill to amend an earlier bill, and then it all gets kind of merged together, and you can't always tell, but you usually can't tell, where the original language in the bill or in the law was and what was added to it by a subsequent term of Congress. So under the Civil Rights Act of 1866, again, there was no magic number of employees. You could have an employer who has just one employee. Or I guess you'd probably have to have two, because you'd have to have somebody hiring the first one. But you could have as few as 2 employees, and that entity would be covered. So again, everywhere from 1 employee all the way up to, we'll see, one statute provides, there's one that has 75 employees. I'm trying to think of any statutes that have a higher threshold than that. That may be the highest. Okay, so let's think about a scenario here. We have a company and it has 2 supervisors, 7 painters, so we have 9, 4 helpers, we have 13, 2 schedulers, we have 15, 2 carpenters, we have 17, 1 office manager, we have 18 employees. They're all permanent workers of the company, so we're going to be able to meet that 20 or more weeks threshold. And so we can see that Title VII is satisfied because we're above 15, but the age discrimination in employment is not satisfied because we're under 20. The Civil Rights Act of 1866 would also be satisfied. So we can see also the Americans with Disabilities Act, which I don't have listed here, but actually the Americans with Disabilities Act is also 15. So we can see here, you can have a situation when you're between that 15 to 20 where some of these discrimination laws apply, others don't. We're going to return to the topic of agency. We had a significant discussion about that in the earlier lecture, so I'm not going to spend a lot of time on this, but you'll see some terms that we've worked with before, respondeat superior being the more narrow term, and that vicarious liability being the umbrella term. Then we have the general rule here, which is the agency rule, the vicarious liability respondeat superior rule. Here it's stated, employers are legally responsible for the actions of their employees while the employees are acting within the scope of their employment. If you'd like to, you could offer this as a definition for respondeat superior. Sometimes it's nice to have more than one definition. I have 3 definitions. We've had earlier definitions of these terms. You may want to look these over and see which definitions make most sense to you, seem most intuitive to you. But they're very, very similar to the definitions we saw before. So I'm not going to spend a lot of time on this one. But this is some new material that we haven't talked about. Because one thing you see up here, we have this language within the scope of their employment. When we talked about agency before, we didn't focus on this language. You may recall we had Bob the cashier at Bullseye, and he punches Claude in the nose, Claude the customer. And we were concerned about, well, what is Bullseye, what's his level of responsibility going to be? Well, I didn't talk about the scope of employment, but now we're going to kind of get down one more level. We're going to kind of peel the onion and get to the next level. And here we have 3 requirements for the scope of employment. The first one is, did whatever happened relate to the work the employee was hired to perform? So what was Bob doing immediately before he punched Claude in the nose? We'll assume he was taking the items off the conveyor belt, moving the wand, with the barcode reader over the item, putting it into the bag. He was doing his job as a cashier. So I would say that he was performing his work. So in our Bob the puncher scenario, we would check this one off. The next thing is, did Bob's actions take place substantially within the workplace and during work hours? Well, he was certainly at his checkout lane, so he was at his workplace, and he was clocked in, scheduled to work, so he was during his work hours. And did his actions serve at least partially the interests of the employer? Well, this is a little bit more complicated because certainly Bob's action of badging the items, not badging, wanding the items and putting it into the bag was advancing the interest of the employer. But punching Claude in the nose did not advance the interest of the employer. And so this is one that you kind of put a little bit of a question mark about. Does it fit this qualification or not? And so you might want to drill down into some cases to see when an employee kind of goes postal or off the rails while they're doing their job, and their temper tantrum, so to speak, isn't advancing the interests of the employer. How have the courts addressed that particular issue? But these are the things you want to keep in mind when you analyze these cases. So let's consider this case. So Mary's a salesperson. She's showing a customer how to use a hedge trimmer, I guess in the hopes of selling the hedge trimmer. And while she's doing it, she cuts the customer. This is not a recommended policy or practice to do. Customer's hurt bad enough, has to go to the hospital. Well, let's go through Mary's actions and see how it fits. So we're going to assume that Mary was an employee, so we already have this one satisfied. So what we're focusing on was she acting within the course and scope of her employment. So did her actions relate to the work that she was hired to perform? Well, let's assume as a salesperson, her job is to demonstrate how the equipment she's trying to sell works. So that seems like a pretty easy yep. Did the incident take place substantially within the workplace and during work hours? Again, it seems to be true. She was at work in the greenhouse, and she was scheduled to work, clocked in at that time. Did her actions serve at least partially the interest of the employer? I'm going to say yes for this one. Obviously, it wasn't the interest of the employer to cut the customer, but demonstrating how the equipment works certainly was useful potentially to a customer. And this obviously is an accident. Now, if it was intentional, let's say the customer started fussing at Mary, you're doing a bad job demonstrating or something, and Mary intentionally cut the customer, you might have a bit of a question mark here. But since it's an accident, I'd have to say that yes, we've satisfied all three of the elements, and so therefore, yes, clearly Bob's greenhouse with the employer is vicariously liable because Mary was acting within the course and scope of her employment. But let's change up the facts a little bit. Let's say that Mary's still a salesperson at Bob's greenhouse, and a customer approaches her and asks her some questions about the hedge trimmer. Mary is the only one who's working that day in the greenhouse. And as she's talking with the customer grabs his chest and falls to the ground, apparently having a heart attack. Mary immediately dials 911, and she then starts performing CPR on the customer. Unfortunately, it's been a lot of years since Mary's performed CPR. She doesn't do it correctly, and she ends up breaking some bones in the customer's rib cage. The ambulance arrives, they take the customer away, the customer survives, thankfully, but the customer wants to sue Bob's greenhouse because of the broken ribs. Let's see how that would play out with our analysis. Okay, so were her actions, did her actions relate to the work the employee was hired to perform? No, she's not an EMT or a nurse or a doctor. She's hired to be a salesperson. And ordinarily, we don't think about salespeople needing to perform CPR. Now, I suppose that it could be Bob's greenhouse has a very customer-friendly policy, and it might require all of its employees to be trained in CPR. And if that were the case, then perhaps it is a part of the job. But as I said before, no, that wasn't the nature of this particular position. There was no expectation that Mary would know how to perform CPR. So this one is a no. We haven't satisfied this element. Of course, we have to have all three satisfied. This is an and, not an or. So we don't even have to go further, but let's continue going on. The next one is going to be true. She was in her place of employment. Mary was at work, and she was clocked into work. So both of these are satisfied. And certainly her efforts did advance the interests of her employer. It's bad business if your customer dies on your workplace. That's going to cause other people not to want to go to your business. And certainly that one customer isn't coming back to your business if he's dead, right? So we have satisfied two of the three categories, but we need to satisfy all three. So I would say in our amended facts, Bob's Greenhouse is not going to be liable. There's another reason why Bob's Greenhouse would not be liable, and that's called a Good Samaritan statute, which we have in Texas. It's kind of beyond the scope of this class, so I'm not going to get into that, but if you're familiar with it, you may have identified that that's a secondary reason why Bob's Greenhouse and Mary would not be liable. Okay, so sometime, we were talking before about when the employment is within the course and scope, or excuse me, when the action is in the course and scope of employment. But there are some times when it's outside the course and scope of the employment that still the employer may be responsible. So let's consider this situation. If you think about it, here we have all of the employment which is within this course and scope of employment. And then we have the whole universe of stuff outside. And we just finished talking about all of the situations that fall within this bubble. And now we're going to talk about things that fall outside the bubble. And we'll see, when do those activities also mean vicarious liability applies? So employers may also be liable for harmful actions of their employees that are outside the scope of employment if, and now we have an or. So when we see an or, it means we can have this one. If we just have any one of these three, there's going to be vicarious liability. We don't need all three. So this one, we needed all three. If we had two but not three, we didn't fit into the course and scope of employment. But here we just need one. If we have two, that's even a better fit. But a single one is enough. What I like to do when I have a list like these, let me go back to the end, is I like to whatever, see whether it's an and or by looking at the next to last item on the list. And what I do is I go back and write and on all of these. If it's an and of course there might be 50 of these, so this is a short list, so it's necessary to write it, but here I'm going to put or, just so I don't forget that it's an or an and situation, whichever might be the case. So one is the employer intended the harm to occur. Let's go back to Bob punching Claude. Obviously Bullseye didn't intend for Claude to get punched. If we go back to Mary with the hedge trimmer cutting the customer, obviously Bob's Greenhouse did not want the customer cut. When Mary performed a CPR incorrectly on the customer, obviously Bob's Greenhouse did not want the customer to have broken ribs. So we can say in all three of our examples that this one wasn't present. So I'm just going to do no, no, no. Let's look at our next one. The employer was negligent or reckless in allowing the harm to occur. Well, let's go back to Bob, the cashier. We'd have to know more about the situation. Maybe Bob had a history of blowing up at people. Maybe he had a criminal record where he got into fights, or maybe he was fired from another position. And if Bullseye had done its due diligence in doing a background check regarding Bob or checking his references, maybe Bullseye would have found that out. Or perhaps Bullseye had observed these inappropriate behaviors in the workplace. Obviously not to the extent of nose punching, but maybe Bob had threatened other people or had said some things that were inappropriate. So we need to know more to see if Bob or Bullseye had noticed that Bob might be dangerous. Thinking about Mary's accident with the hedge trimmer, again, you'd have to see, well, was Mary properly trained on how to use the hedge trimmer? Maybe she was given and said, show it to people, and wasn't told how to safely handle that equipment. Well, that would be a case of negligence or recklessness. Similarly, if Mary had a history of being negligent or reckless with that particular piece of equipment or other piece of equipment, that would be an indication that the employer should have given her more training or moved her to a different spot or perhaps dismissed her. So we just don't know enough about that. The third one, though, I'm going to say Mary's failure to perform CPR reasonably. I don't think that that's reasonable to expect salespeople to be experts in CPR in this circumstance. So I think that it wouldn't be negligent or reckless of an employer to fail to train salespeople about how to perform CPR. So let's look at our last option, because again, we only need one of these, and that is the harmful actions were aided by actual or apparent authority conferred on the employee by the employer. And so obviously here we have, and let's just talk about these terms for a second. Actual authority is when the employer actually gave the employee the authority to do whatever it is. Literally told the employee, do this or don't do this. Or maybe it's in a manual somewhere. It didn't have to be an actual conversation, but somewhere it's documented that the employee can do this. Apparent authority is a little bit more vague. This would arise when the circumstances suggest pretty strongly that the employee was reasonable in doing this given the employment relationship. Now, obviously, Bullseye did not give Bob either apparent or actual authority to punch Claude in the nose. Similarly, I would say that Mary had actual authority to demonstrate the equipment. So I think you could say that yes, that one would be in effect. Obviously, she wasn't given actual authority to cut people. With respect to the CPR, I don't think that there would be any indication that there was actual or apparent authority to do that. I guess you might be able to make the argument that because she was the only person working there at that time, that she had the authority. She certainly would have had the actual or apparent authority to call 911. I think that would be a stretch, but I'm going to put a little question mark there, because I suppose since she's working by herself, we might make the argument she had actual or apparent authority to perform life-saving activity. So what I'm trying to show is that you have to look at each one of these from a fact perspective. And all of these examples I just went through, you can probably go out there and find a case where there were pretty similar facts. So you're not just left to your imagination. You can actually find cases that have a fact pattern fairly similar to the one that you're confronting. So employment law, based upon those agency principles that we've been talking about, it requires that the employee act in a way that is consistent with his or her authorization. Of course, employees sometimes don't do that. If employees always did what they were supposed to do, employment law would be a course of about, 5 hours, right? It wouldn't take very long at all to get through it, but that's not the human experience. So the reality is that employees often do exceed their authority. Let me give you an example it's very common in large retail companies. Large retail companies often have security in those facilities, and there's different ways of doing it. Some hire actually outside businesses so they're like a leased employee model that we talk about. And in fact, sometimes these employees are armed. Sometimes businesses will hire police officers to function that role, and in most cases, the police officers would also be armed. But probably the more common method is to have actual employees have this role, and they may be called security or they may be called loss prevention folks. The people who go into this area are oftentimes people who aspire to become peace officers, police officers, or have other roles. Sometimes they might have been salespeople within the store, but more commonly they have a different set of career goals and kind of a different set of life experiences. As a result, they enjoy the, I guess you could say, detective aspect in many cases of identifying somebody as a shoplifter and giving the evidence to justify approaching that person and questioning that person. When you are in that situation, there's adrenaline flowing. It's exciting. It's you feel a little bit like you're in a cops and robbers movie to some extent, and as a result, situations can escalate pretty quickly. As far as I know, all large retailers have a policy that you don't follow shoplifters who run outside of the building. Once you cross the threshold, once you're outside of the building, the general rule for, as far as I know, all retailers, and certainly most retailers, is that the chase stops there. You can call the police and have them continue the matter, but you can't allow your loss prevention folks to leave the physical footprint of your building. And that rule is primarily in effect for everyone's safety, for the general public safety, for the safety of the loss prevention officer, and even for the safety of the fleeing shoplifter. Because let's face it, shoplifting, is a crime, but it's not a crime a person should die for. And so, as people are running out of the building, and most of the time these buildings are very, adjacent to a parking lot, there's cars in the parking lot. And sometimes it happens that the shoplifter is fleeing, thinking he's going to be able to avoid arrest if he runs fast enough, but as you're running, you're not looking every which way. And there, unfortunately, have been cases of people being hit by cars that are driving around who aren't expecting to see someone run out in front of them. And so as a result, loss prevention officers are not usually supposed to leave the building. But your adrenaline is pumping, and you have this person dead to rights. You have them on camera absolutely stealing, and they ran, which is even more clear evidence of culpability. And it's very, very difficult in that situation for that loss prevention officer to give up. That's what they're supposed to do, and that's what they do 99% of the time. But there is that 100th time where they don't. And so you can have all the training in the world, but sometimes people are going to exceed their authority and do what they know they're not supposed to do because of adrenaline, because of hubris, because of a million different things. And so that's just another example of how these things play a role. And so once that employee exceeds his authority, the employer would love to say, oh, that's on the employee. We trained him not to do that. We trained her not to do that. We're not responsible. But the reality is when a third person is injured, maybe the shoplifter, maybe an innocent customer coming into the store or leaving the store, what the court will say is, well, maybe it's mainly the employee's responsible, but you, the employer, are more responsible than that innocent victim. And so you are going to oftentimes be held liable under those circumstances. Let's consider this situation. So Mary is an independent contractor this time. So she's not an employee. And we talked about how it's easier for the company to avoid vicarious liability when the person who's done the action is an independent contractor. It's easier, but it's not a slam dunk. Certainly you can still have vicarious liability with independent contractors. So in this scenario, Mary is driving to Bob's headquarters. So she's clearly on task to do work for Bob, not one of her other customers. She causes a car accident, and somebody is injured as a result of this car accident. At the time of the accident, she was on the phone talking with somebody at Bob. And so therefore, Bob probably has vicarious liability. If Mary had been just simply driving to work, Bob would not be responsible. Even if Mary had been an employee, she hadn't actually clocked in, she hadn't actually started her day at that point, if she hadn't been on the phone with the manager. So it's really, once again, because remember we talked about how it needs to be during working hours. So, but in this case, Mary's working hours had begun because she was already talking on the phone. Let's consider this case. This is a case we're going to spend a lot of time on in the sexual harassment section of the course. I'm going to touch on it here, though, because this does talk about the idea of vicarious liability. And since we're kind of revisiting that issue, this is a good and important case to talk about. This is also another example of how I've set up our case summaries. Again, we have that issue. We'll always start with the issue. It's going to be in a question format. Can an employer be vicariously liable to an employee even though the employee did not suffer adverse tangible job consequences from the wrongful actions of another employee? And our answer is yes. But our answer is it depends as well. Yes is probably the best answer, but it's not an automatic, every single case. Yes. So we have the facts of this case, which I'm not going to spend time on, but you can see I will include a brief summary of the facts here. So we'll go on to the next page. And then in the previous case, we didn't have a procedural history, but I showed a procedural history here. It's sometimes helpful in these cases to know how a case proceeded from the trial court to the final court that considered this. And so I have included that analysis here. I don't include it in every single case, but I think it is oftentimes helpful to know a little bit about how the case gets from the trial court to the final court. But here is the section that's probably the most important. And that is, here's the holding. When a supervisor's sexual harassment culminates in a tangible job action, we're going to talk about what this is in just a second, such as dismissal, an undesirable reassignment, or an actionable hostile environment, the employer is vicariously liable. But that's not all it held. It also held that an employee who experienced sexual harassment that did not suffer adverse and tangible harm could still sometimes recover against the employer without showing the employer was negligent or at fault, but such liability was not automatic. So here, this is automatic. The employer can't do anything other than train its employees not to engage in this behavior, but once the employee has done something naughty and we have a tangible job action, liability for the employer is automatic. There's just no way around it. But when there hasn't been that tangible job action, the liability is not automatic. So we'll need to drill down. In the next slide, we'll see more about that. But before we go to the next slide, let's be a little bit more granular about the term tangible employment action. We probably know the word tangible to mean touchable. An idea isn't tangible, but a paperclip is tangible. A piece of paper is tangible. A piece of software isn't tangible. Something that can't be touched. When we use the word tangible here, though, we're thinking more metaphorically. So don't be too literal about this term. A tangible employment action is an action you can point to a particular decision on a particular day that had a particular repercussion. So dismissal, that's pretty darn clear, right? When you're told you are fired, that is a tangible job action. It's not ambiguous. It's not like you don't know the day that it happened. Or you are reassigned. Again, very clear. One day you're in Department A, the next day you're in Department B, pretty clear. An example of an intangible job action would be people stop being friendly to you. Well, that's a matter of interpretation. The fact that somebody doesn't say hi to you on Monday when they said hi to you on Friday, maybe they're just having a bad day. That is a less cut and dried, a less certain analysis. Or when, in the past, you occasionally had to do that unpleasant task, and it seems like maybe you only did it 5% of the time, and now it seems like you do it 10 or 15% of the time. Again, that's a pretty subtle difference. If you're suddenly told you're going to have to do that unpleasant task 3 times as often as you did before, that would be a tangible employment action. But when it's unclear when the decision was made and who made the decision, and was a decision really made, or did it just start happening that way, that would be an intangible situation. So that's kind of the distinction here. We've talked about what happens when it's a tangible job action. Now we're going to talk about when it's intangible. We know the liability is not automatic, but how do we know whether we are in a situation where vicarious liability attaches or a situation where it doesn't? Well, let's go to the next slide. Let's pause and talk about the idea of affirmative defense. If you've taken civil litigation, you probably are already familiar with this term. We also have this term in other substantive areas of the law, so you may have heard it elsewhere. Let's pause for a second and talk about burdens of proof. When a plaintiff files a lawsuit, we think about the plaintiff as bearing the burden of proof. It's his or her job to persuade the trier of fact, typically the jury, that it's more likely than not that it happened the way the plaintiff said, if it's a civil case. If it's a criminal case, then the prosecution, which kind of acts in the role of plaintiff, his role or her role is to say, or to persuade the jury that it's proof beyond a reasonable doubt. That's the burden of proof that, in that case, a prosecutor bears. The defendant, in either the civil environment or the criminal environment, doesn't have any burden of proof. His or her job is to chip away at the evidence that the plaintiff presents, or to present additional evidence that kind of puts into question the facts that the plaintiff or the prosecution is putting into effect. And so all his job is, the defense job is to make that evidence level that the plaintiff has achieved slightly below that legal requirement, be it preponderance of evidence or beyond a reasonable doubt evidence. That's how it happens in the vast majority of cases. But there are some situations where the defense actually does bear the burden of proof. And those would be when an affirmative defense is being raised by the defendant. Let me give you an example. If I am the defendant, and let's say it's indisputable that I caused the car accident. There's just 50 witnesses who all say I ran the red light. There was a red light camera there that recorded it. A police officer was there too, and he or she saw it. Just so much evidence that there's just no way the jury's not going to believe I ran the red light and caused the accident. But, and this is a civil case here, so keep that in mind, but the plaintiff in this case waited to file his lawsuit beyond the statutory period. Let's say the statutory period was 3 years in this jurisdiction for this type of claim. And he waited 3.5 years before he filed his claim. Well, in my lawsuit, or excuse me, in my defense to my lawsuit, when I file my answer to the plaintiff's lawsuit, I'm going to raise as an affirmative defense that the plaintiff is time barred because the statute of limitations has expired. But because this is an affirmative defense, it's my job to prove it. It's not the plaintiff's job to disprove or to prove that he filed his lawsuit within the statutory period. It's my job to prove he didn't do that. Sounds like it'd be pretty easy for me to prove that, because we're going to have all these witnesses who say, well, the accident happened on XYZ day, whatever that day is, and we can see the date that the lawsuit was filed. Just do the math and figure it out. So it's not going to be hard for me to prove that, but it's going to be my job to prove it. And so this is a situation where the employer, who is the defendant in employment discrimination cases, has the burden of proof. Ordinarily, the defendant in these cases doesn't have to prove anything. It's the plaintiff's job to prove. But when we're looking at affirmative defenses, we're flipping that and we're saying, now, the employer has to prove this. The plaintiff can chip away at the evidence that the employer is presenting in support of the affirmative defense to hopefully cause the employer not to meet the burden, but the plaintiff doesn't have any of its own burden in this area. So let's see if the three things that the employer has to do, actually two things that the employer has to do, sorry, and we're in it and territory, so it's both of these have to be done. The first thing the employer has to prove is that the employer exercised reasonable care to prevent and correct any sexually harassing behavior. So did the employer have, for example, a sexual harassment training program so that its employees knew to avoid sexual harassment and knew to report sexual harassment when the employees would see that type of behavior? Did the employer have a reporting process with multiple ways that that employee could report the behavior? These are the things that the employer would need to demonstrate to show that it exercised reasonable care. And the next thing it's going to have to do is show that the victim unreasonably failed to take advantage of that preventive or corrective procedure. So the A existed and the victim refused to do or take advantage of A. And the victim's refusal was unreasonable under those circumstances. So if the employer is able to prove both of these elements, then the liability isn't going to, the vicarious liability isn't going to exist. Now, to be clear, the harasser is always going to be liable, whether we have a tangible job action or not. So if Bob sexually harasses Mary in the workplace, and then Bob causes Mary to be dismissed, well, Bob's and Mary's employer is going to be automatically liable, and of course Bob is going to be liable. But let's say Bob harasses Mary, and there is no tangible job action. Mary just feels really uncomfortable at work. Well, Mary sues Bob and their mutual employer. Bob is always going to be liable, but if the employer followed this first step and Mary unreasonably failed to follow this policy, then the employer escapes vicarious liability. But Bob is always on the hook because Bob sexually harassed. So keep in mind that the harasser is never off the hook. Usually, though, from the perspective of the victim, it's not that helpful to sue the harasser because the harasser, again, doesn't have the deep pocket. As a result of the Ellerth and Farragher case, we see that employers are going to have sexual harassment policies and are going to offer sexual harassment training. This defense is called the Farragher-Ellerth Affirmative Defense. So in Quizlet, you're going to want to include this definition. We'll, of course, spend a lot more time on this material when we get to the sexual harassment and just generally the other harassment material that we cover in other modules. We have another case, and this case is not an important case. The Ellerth case is important, and let's see the other case. I guess that's the only one we talked about. So the Ellerth case was important. So we did, okay, all right. And this next case, though, isn't important. It's an example of a case. So you don't need to know the name of this case or any particulars about this case. Can an employer be vicariously liable for the actions of an employee who lacks decision-making authority? And I'm going to say here it depends. The answer in this particular case is no, but it's a little bit more complicated situation than maybe that answer displays. We'll talk about why it's more complicated than this case communicates. So Hill engaged in some misconduct, and she was fired. The company had clear policies about if you do this many times, the consequences being fired, and Hill did whatever the behavior was the required number of times, and so she was dismissed. She was replaced by somebody who was 10 years younger than her, who was a male. And so she's alleging, I'm guessing, age discrimination and sex discrimination. Hill doesn't dispute the facts, but her beef is that a particular person reported her for these violations, and that person wanted her out of there, perhaps because she was a woman, perhaps because she was an older person. So what he was reporting was factually true, but he was reporting it because he wanted to discriminate against her. Now, when he reported Ms. Hill's actions to the higher-ups who made the decision, no one is arguing that the higher-ups had any discriminatory animus, and the word animus, by the way, means anger or hostility towards the person. And so no one is saying the higher-ups probably didn't even know who Ms. Hill was or even know what her age was. And so the higher-ups had no discriminatory reason to get rid of Ms. Hill. But again, Ms. Hill's point is, yeah, I get those people didn't know me, but Fultz certainly did, and he wanted me out of here because I'm a woman or because I'm older. Well, the court sided with Lockheed, the employer, and concluded that Hill did not prove intentional employment discrimination. She failed to prove that the other managers, the higher-ups, who actually dismissed her, were aware of her claims or that any of those higher-ups acted with improper motives. So in this case, this is a good result for the employer, but I wanted to mainly focus on the cat's paw doctrine. So this is a good definition for the cat's paw doctrine. This court, the Hill court, did not choose to use the cat's paw doctrine. It could have. This seems to be a fact pattern that can follow that doctrine. Whether the court that you're in front of would follow the cat's paw doctrine or not is really going to vary. It is certainly a tool that is available, and you can count on plaintiffs talking about it. So you may be saying, well, what is the cat's paw doctrine? Okay, so this is when an employer's decision can be considered discriminatory, even if the person who made the decision had no discriminatory motive and was acting on a completely legitimate concern. This is true if that decision maker was relying upon negative information from another person who did have an unlawful discriminatory motive, and even if they weren't lying. So let's imagine for a second, and I don't know if this is factually true, but let's imagine for a second that while everything that Fultz reported about Hill was true, Fultz would routinely overlook safety violations by men or safety violation by younger workers. But he was always noticing every single safety violation that Hill did. So when he reported Hill's violations to the more senior people, he wasn't lying, but he was being selective and discriminatory about what he chose to reveal and what he didn't choose to reveal. And so that would be a case where you could apply the cat's paw doctrine. Imagine for a second that I am a Hispanic woman in my 60s and I work for a business. Let's say I'm in middle management. And my boss, who doesn't like me because I'm a Hispanic woman in my 60s, wants to get me out of there, employment. He identifies failings that I have. They're true. I'm not a perfect worker. But a lot of my colleagues also have similar failings, and he's not writing them as nearly as hard as he's writing me. And so he reports those failings to senior management. It just so happens the senior manager is also an Hispanic woman in her 60s. So obviously that person would be highly unlikely to discriminate against me because we fit into the same demographic group. So the manager reports my misconduct, and the senior manager goes, well, that sounds like a situation where you need to dismiss this person. And I'm dismissed. I file a lawsuit. The employer says, well, look, the person who approved the dismissal is the same race, the same national origin, the same age, the same gender. So it can't be discriminatory. But again, I can assert the cat's paw doctrine and say, yeah, I agree, but that person didn't know the whole story. The person knew a selective amount of the story. The discriminator isn't the decision maker, it's the person who gave information to the discriminator. So this is an important thing to keep in the back of your mind. Many times we forget to consider, how did the decision maker know what he or she knew? And how complete of a version of the story did he or she have? Okay, so we're almost done here. This is we're going to return a little bit, I guess, to the larger issue of talking about the employer. And an important concept in this situation is the idea of an integrated enterprise. I don't necessarily have a definition here. You could just take some of the material here, or you could Google the term to get a more tight definition. But this goes back to the idea that many times an entity may exist on paper in a certain situation, but in reality actually function in a different situation. Let me give you an example. When I was at JCPenney, at times we had hundreds of different legal entities, some of them corporations, some of them limited liability partnerships, some of them limited liability companies, and how they were related to each other was very different. But the different employees of these different entities from a day-to-day basis all work many times in the same department, in the same floor. And from a day in, day out, what do you do, who do you do things with, it was not something people were aware of, or that it directly impacted how they meted with people or how the workplace continued to exist. So it could well be the case that you could have one person working for one corporation of this larger entity, and another person can work for another corporation, this larger entity. And so they have different employers, but from a practical sense, they work for the same company. There are some retailers who actually incorporate each one of their branches. And so that can be another way that this plays out. Sometimes there can be businesses that are in some sense separate, but are in other senses not separate. But they're so closely, and it's especially true for smaller companies. For example, you might have an entrepreneur who owns several different businesses, or maybe has family members who own several different businesses. And organizationally, they're distinct, but from a day-to-day practical sense, they are very much one unit. And so the EOC isn't as focused on the technical, legal, organizational chart, how one entity legally fits within another. More interested in how the reality of these working relationships are. So be aware that you're not going to be successful if you just say, oh, hey, you know what, we've got a really complicated corporate structure, and that person doesn't even work for the same entity as someone else. So they can't possibly be co-employees. No, that's not how it works. Keep in mind the concept of an integrated enterprise. So at this point, we have completed our third section of Module 1 about the nature of employment relationships. We have discussed how a business can be an employer or a principal in an agency relationship. In our next lecture, we're going to talk about our last category, which is about when that employment relationship ends, especially how non-competes play out. This one I think has some surprises for you, perhaps. Some of the rest of the stuff you may have seen what was coming a little bit, but I think very likely some of the information in the next segment may be fresh information for you. Anyway, I thank you for your attention today, and I hope you have enjoyed the presentation. Take care.